Well, good day. It's Dr. Dan Ashbourne, the Executive Director at the London Family Court Clinic, talking to you today about the ADR Link program and the ODR referrals and services that can be made available through our agency. The various slides will be shown to you and provided, but just wanted to let you know that I want to thank you for this opportunity. I am a psychologist and executive director at the Court Clinic, but also an accredited family mediator through the Ontario Association for Family Mediation. First of all, acknowledgement of our traditional territories and homelands. As we forge forward and continue working with Indigenous nations, we want to acknowledge and respect and recognize the deep connection and the historical relationship between Indigenous peoples and the land they are connected to. Land was stolen. Many Indigenous people were killed intentionally. First Nations cultures, languages, and traditions were also decimated due to cultural genocide. We acknowledge that colonization, residential schools, the 60s scoop, and other factors have significantly undermined Indigenous cultures. With support, accountability, and much respect to Indigenous peoples, we work within Southwestern Ontario and of London area. The following traditional territories are Anishinaabe, which includes the Ojibwe or Chippewa Nation, Haudenosaunee, also known as the Iroquois, which includes the Oneida Nation, Lenape, also known as the Delaware, Atawandra, also known as the Neutral, and the Wendat, also known as the Huron. The land in the area we call London is the traditional territories of the Chippewa of the Thames, the Oneida of the Thames, and the Munsee Delaware Nation. There are 11 First Nations communities in the region of Southwestern Ontario and over 120 in the province as a whole. With much respect, we must embrace the concepts and significant cultural concepts of traditional ways of knowing to the needs of autonomy and integrity to the Indigenous families we provide services. Wherever possible, we strive to respect all cultural, religious, and regional differences among our Indigenous children's culture, heritage, and concepts of extended family. The London Family Court Clinic, our vision is caring communities, resilient children and families beyond the justice system. Our mission, integrating specialized clinical practice, education, and research that promotes resiliency in children and families to move beyond the justice system. Our philosophy and mandate, the clinic recognizes children and families involved in the justice system are in a crisis and at a major turning point in their lives. We believe the justice system has an opportunity to be part of a healing and conflict resolution process when it is responsive to the needs of children and families. We believe the clinic can play a role in making the justice system more sensitive and responsive to families. Our principles, respect and trust, inclusiveness, service excellence, collaboration, valuing clients, staff, and volunteers, accountability and transparency, and culture of success. So what is ADR Link at the London Family Court Clinic? This program connects families involved in child protection matters with the Children's Aid Societies to various ADR practitioners in the Southwest region of Ontario. Referral agents make referrals with families' consent to ADR Link, who then matches the case with a qualified professional working in that geographical area. ADR Link maintains a roster of qualified ADR practitioners accepting cases in any part of its catchment area and operates out of the London Family Court Clinic. Practitioners are all accredited or certified through either the Ontario Association for Family Mediation, the George Hall Centre, or are qualified ODR practitioners. Funding is provided by the ministry. ADR Link is the transfer payment agency that oversees the funding and provides the support for the referrals. And payment is made to practitioners for things like the cost of a circle, food, childcare, consultant fees, etc. Our focus is connecting alternative dispute resolution or ADR practitioners with neutral resolutions to provide alternatives for families to court. What is alternative dispute resolution, you may say? It's an alternative method to resolve a dispute between a family and a child protection agency. It's an alternative to the traditional court process. It involves the role of a neutral facilitator to conduct the alternative dispute resolution process. It's voluntary and requires the participants' consent. And it's a process that focuses on facilitating the parties to find a solution upon which they can agree. And it is to be culturally responsive and approved. When might you use ADR? The Child, Youth and Family Services Act reflects that if a child is or may be in need of protection, all societies must consider whether a prescribed method of ADR could assist in resolving any issues related to the child or a plan for the child's care. Furthermore, with the consent of all parties, a court may adjourn proceedings at any time to permit the parties to utilize a prescribed method of ADR to resolve any dispute. This includes applications to vary or terminate an openness order before or after an adoption. With regards to the criteria for referrals to ADR Link, the following is in place. Any of the following apply. A court intervention is being considered. A court intervention has been initiated. A court intervention is in progress. And the family is consenting to consider alternative dispute resolution. Further, informed consent is obtained once the family has met with the ADR practitioner and agrees to proceed. Family involvement continuum. What you'll see here is a scale where one side focuses on family voice in decision making and the far side focuses more on a system perspective making the decisions. And through the ADR ODR process, the goal is to ensure that families and communities are involved in the decision making process. So at the family side of the continuum, families along with their support network craft initial plans that are subsequently shared with the professionals who work collaboratively with the family to ensure it is attainable and meets the highest standards for achieving the goals of safety, permanency, and well-being for the children. We see that families are part of the decision-making team. In these instances, the families partner with professionals to create consensual decisions that are acceptable to all parties. Families have a genuine voice at the meetings. Their ideas, needs, perspectives, and other inputs are sought at the meetings, but the decision-making may involve professionals, and as it slides more towards the far right side, the professionals make the decisions. So in the ODR process, we're hoping to maintain the decision-making within the family and the community. Possible ADR referrals could be anything such as the following: planning for a new baby. There might be risks that the children could come into care. There could be addiction or mental health struggles or neglect. Parents may have some developmental delays. There may be a parent who's incarcerated. There could be parent-teen conflict at the root of it. There might be society involvement seeking supervision. Could be that it's a high conflict parenting plan issues that are at play. Domestic violence or family violence may be part of the situation. Could be issues with transiency or housing challenges. Could be dynamics in regards to chronic neglect, marginal parenting, that kind of thing. Parents may not be agreeing to some of the supervision order stipulations and thus needing to come together to make some decisions. It could be that the referral is because there's more than one kinship plan that's being presented and there needs to be sorting out about what's best. Could involve planning for a child with special needs or trying to sort through the openness agreement with regards to adoption. Could be planning for children leaving care or who are older children involved with a voluntary youth service agreement that's expiring and needing some support. Could be in regards to interim or extended care clients wanting to leave care early, or it could be disputes about access, parenting time issues. And it might be that it's making plans for moving away from agency supervised access as examples of possible referral. The referral model has shifted over time. The ADR link has been around since 2006, 2007. And the referrals were originally only coming from children's aid societies, but that's changed over the last few years. Now, a children's aid society or Indigenous community members with family consent can make a referral to ADR link. If court is being considered, has already been initiated, or is already in progress. Then the ADR linked service processes and assigns the referrals to a practitioner who's on the ADR link roster. And this neutral practitioner then facilitates the ADR ODR process with family, CAS, and First Nation representatives, etc. You see a listing of the various children's aid societies that are involved in the Southwest region, as well as a number of the First Nations communities that are eligible to make referrals and that we are funded to assist. There are actually 4 different methods of ADR, ODR being one of them. So let's take a look at those methods in case folks have some questions about that. One method is called family group conferencing or family group decision making. And here, the family group conference practitioner helps extended family members create a plan for the children that must address the child protection concerns. And the idea is that the children would be returning home or be placed with kin. And it involves some private family time for developing of the plan. The practitioner facilitates the process and is someone who's been trained and certified by the George Hull Center through their training process and mentorship program. Bottom right, child protection mediation is another form of ADR. Here, a child protection mediator helps reach an agreement on a disputed issue or issues, helps facilitate and generate options for resolving the dispute. It helps develop a mutually acceptable plan that addresses the identified child protection concerns. And the mediator is someone who has been trained in child protection mediation and certified by the Ontario Association for Family Mediators. Top right, the original dispute resolution, ODR or IDR, depending on where you are, involves original dispute resolution practitioners that draw on traditional ways of decision-making from communities. It's typically based on healing circles or talking circle practices. The method relies on involving community elders and sources of traditional knowledge and healing as part of the process. The ODR practitioner qualifications, again, it's someone who's neutral, who's received a criminal records check, who has knowledge about the Child, Youth, and Family Services Act and ODR approaches, and who has been accepted by the First Nation to do the ODR work. So it's approved by the community. And finally, there's a fourth option. The fourth option, practitioners help facilitate when there are unique circumstances that do not fit the other ADR methods. It must be approved by the executive director of the Children's Aid Society. And again, it may draw on the skills and approaches that unfold in family group conferencing, child protection mediation, or ODR methods. And it's really about engaging a senior ADR practitioner with various qualifications to help facilitate this specialized planning on behalf of children. Today we're sharing information with you because we're really hoping to build capacity across all of the First Nations communities in the Southwest that are linked into the London Family Court Clinic and the ADR Link service. Our goal is to create awareness about alternative dispute resolution processes and original dispute resolution methods that are funded through ADR Link. We want to develop an ADR ODR approach that's accepted in your communities. We want to help develop and seek guidance from an ADR Link Indigenous Steering Committee, drawing from our various First Nations communities. We want to develop a referral process for each community to refer directly to ADR Link. And of course, we want to increase the number of practitioners available to do particularly ODR for the various communities, and to expand the ADR Link roster of ODR practitioners. So to do that, the criteria for joining the ADR Link roster of ODR Indigenous approach practitioners, again, you must be accepted by the First Nation community to practice ODR or Indigenous approaches of ADR. You have to be someone who's seen as neutral in the community that's being served. You have to have knowledge of the Child, Youth, and Family Services Act and ODR methods. And again, a satisfactory police criminal record check having been completed. Follow-up questions in regards to the ADR Link services available at the London Family Court Clinic. You can contact 519-679-7250, extension 109. Or you can use the cell connection that's provided or the fax number that's there, or go on our website at adr-link@lfcc.on.ca or at www.adr-link.ca. Thank you once again for this opportunity to speak with you and to be able to share these slides with you. We'll make sure that the materials are available and some information in regards to consents, some information in regards to an overview of the different models and how it unfolds, and again, these slides. Thank you for your time.